Good morning, all.
Morning.
As we resume this Commission of Inquiry, I wish to give some information. There are queries that have been sent to this commission regarding the position of the chair. I wish to say at this time that Justice Wade Miller has been appointed as chairperson of this Commission of Inquiry. She still remains in that position. She is dealing with matters dealing with herself, personal matters, and in the interim, she has asked me to sit on the matters to preside over the commission. So with that said, we'll continue with matters of the day. Counsel?
Morning, Chairman. Morning, all persons present. Chair, could I just also for the record indicate that Mr. Stovall, and also for this matter, Madam Justice Wade Miller had recused himself from this matter?
Yes, Counsel. I'm glad that you reminded me of that fact. She also has recused herself from this matter because of professional reasons in her previous position.
As also Mr. Stovall.
And also Mr. Stovall. I wish also to point out that Commissioner Binns has returned physically to the Commission. She has been on our Zoom meetings and by that way present electronically. And I might as well expand and say that this Commission did meet yesterday by Zoom. So just for the public edification, this Commission sits via Zoom electronically because of the COVID situation where we are not actually sitting physically and hearing matters from persons of standing. Thank you very much. Counsel, you may continue.
Thank you. This morning we have the matter of claim number 035. It's a Robert Mulder matter. The applicant wishes to, he submitted a claim regarding his own property and what has been characterized as false adverse possessory title. I wish to ask to have the claimant sworn or affirmed based on his religious or any other conviction to do so.
I swear by Almighty God that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth. Thank you.
Would you state your name, sir?
Sir, my name is Robert Mulder, M-O-U-L-D-E-R. Yes.
Where are you presently residing, sir?
15 Bridge View Lane in Sandys Parish.
On the 8th of June 2020, you submitted a claim to the Commission of Inquiry into historic land losses in Bermuda?
Yes, sir. Would you like me to read it, sir?
Before we get there, the document you submitted, you signed that document?
I'm not sure if I did, Mr. Harrison. Yeah, I'm pretty sure I may have.
And if you see your signature on the document again, you'd recognize it?
Yes, sir.
And a copy of it. Prayer indulgence, Chairman. Your original submission, the 8th of June, it was sent electronically?
Yes, sir, by email.
Thank you. Just going to show you the document which you had sent to us. Just going to ask you to, if you could identify your signature.
Yes, sir.
I'd ask for that document, which is a 8th of June submission of a claim by Mr. Robert Mulder to the Commission of Inquiry.
Yes, sir.
Mr. Chairman, the application to be tendered admitted as Exhibit RM1. Silence, let him read from that one. I'm just going to ask you to read from the document you sent to us, the one that we received.
Yes, that is indexed. The evidence is tendered by email by Robert Mulder, tendered as Exhibit RM1.
You may read the document, sir.
Yes, sir. Okay. I emailed Secretary of the Commission, Sophia House, and I write, Dear Commission, reapplication to participate as a party before the Commission and to present evidence and information relevant to the terms of the Commission of Inquiry. I am writing as I wish to come before the Commission with standing as a party and as someone who has information relating to the terms of the Commission. I have noted with interest that the scope and the inquiry includes inquiry into historic losses of citizens, property of Bermuda through the theft of property, dispossession of property, adverse possession, claims, and any other such unlawful or irregular means by which land was lost in Bermuda. And I'm confident that my experience fits the description, as I was a victim of a false claim of adverse possession. In a Royal Gazette article on the 19th of May, 2014, the late Mr. Walton Brown, MP.
I'm just going to ask you, as it is in the document, you have to read it exactly.
Yes. In a Royal Gazette article on the 19th of May, 2014, the late MP Walton Brown is quoted as saying, many families have had their land taken from them, particularly in the 50s, 60s, and 70s, through a series of illicit practices by a cable of lawyers, real estate agents, and banks. And I believe similar things, inclusive of various examples, were also
Ms.
said.
Mulder,
Let me read this again.
Ms. Mulder,
yes.
For convenience, you may remove your mask.
Thank you, sir. Appreciate that. Okay, so I believe similar things, inclusive of various examples, were also said in the House of Assembly. The above words resonate with me because lawyers, real estate agents, and banks all played a role in my being dispossessed. My land was purportedly, but not really, adversely possessed, and then purportedly, but not really, sold by being included in the deed of conveyance and a deed of mortgage under circumstances where I'm confident that I can show all parties involved knew that my land had not truly been adversely possessed or able to be legally sold. I am confident that what happened is an example of the type of systemic land grab that the Commission has a responsibility for inquiring into, and believe that criminal wrongs were committed by various individuals that ought to be reported to the Director of Public Prosecutions. I am willing to give oral evidence in public and seek to have standing as a party who has been and continues to be greatly affected by the dispossession of my land. My case is an example of how this type of land theft can be accomplished, where people who did not have a valid claim to ownership were provided with deeds, and I have in my possession an abundance of evidence to show how this was accomplished by the creation of deeds and sworn untrue affidavits. I believe that my evidence will also be useful to the Commission in general, as it illustrates how land theft could have occurred in other cases historically, where parties may not have a complete paper trail as I do. In October 1999, a significant area of what was my land, forming part of 10 Bridgeview Lane Sandys, was supposedly sold without my knowledge to Mr. Do I continue the names? Just go ahead. Okay.
Yes. Once you call a person's name,
yes, sir,
that person must, if they've suspected of any wrongdoing or is as alleged
yes,
by
sir.
you as a witness, that person must be sent adverse notice, Mr. Muller.
Yes, sir. Okay. I was just a bit concerned because I was about to start naming people. So, yes, sir. Okay, in October 1999, a significant area of what my land, forming part of 10 Bridgeview Lane Sandys, was supposedly sold without my knowledge to by Michael Cranfield, who owned the adjoining property and claimed to have acquired 1, ownership of my land due to adverse possession, and 2, rights of way over my land due to long use. Essentially, what happened was what I refer to as a land theft by deed, as the supposed purchasers, Paul and Janet Slaughter, were provided with deeds that they later used in 2004 to masquerade as true owners and file a Supreme Court action against me where I was wrongly labeled a trespasser. The outcome of that case over 3 years of litigation was that my ownership was confirmed, and it was found that the Slaughters had no interest in my land, as Michael Cranfield had not acquired ownership or any rights over my land, and he could validly sell. As such, I was able to recover my property, but I would like to stress that at the time of 2004-2007 proceedings, I did not have the evidence that was later discovered to support I did not have the evidence that was later discovered to support that it was a deliberate land grab. I continue to suffer from the effects of the claim wrongly brought against me using an invalid deed. Amongst other things, I have never been compensated for the enormous financial losses due to, amongst other things, a delay in starting an intended development during the years that the court proceedings took place, a complete inability to carry out parts of the intended development, including the construction of 2 new houses and loss of rents. As mentioned above, I have evidence to show that none of the parties involved, including the lawyers, truly believed that Michael Cranfield had acquired ownership of my land in order to sell it, or that the Slaughters were actually buying it. In 2016, I was able to gain access to the Supreme Court file, case number 2009-179. Where the Slaughters and the plaintiffs filed a claim against Michael Cranfield for fraud. Amongst other things, accused him of fraudulently concealing from a letter written by me, and said that he furthered the fraud by causing affidavits to be sworn that did not make reference to the Mulder letter or take into account the assertions made by Mr. Mulder, which he knew or ought to have known contradicted or brought into question his claim of adverse possession. The above may convey...
I was going to ask you just to read as it's on the document. You can't insert.
Yes, Counsel, would you speak a little louder?
I'm just going to ask the witness to read as it is on the document. He can't insert words that are not there.
Okay, Mr. Mulder,
yes.
What part are you saying that I inserted a word? Mr. Mulder, which he knew or ought to have known, contradicted or brought into question his claim of adverse possessory title. The above may convey the picture that the Slaughters were innocent buyers, but I have evidence that they were not, and that aided by their lawyers, they entered into agreement to buy land that they knew Michael Cranfield did not own. Included in this evidence is that Mr. Cranfield says in his defense to the Slaughters' claim The one thing being that he denied making representations that the title to the land had been acquired by adverse possession, which is intended to be relied on by the plaintiffs purchasing the property. The existence of the case number 2009-179 and its contents showed not only that the Slaughters accused Cranfield of fraud, but that Michael Cranfield accused the Slaughters of, amongst other things, knowing that the affidavits that he had been provided with, in brackets, supposedly in support of a claim of ownership of my land, were not truthful and painted a false picture. And in doing so, he revealed that he must have known the same fact. How many parcels of land have been lost due to things like false deeds and false affidavits? I cannot help but wonder. In closing, I would like to emphasize that although I was able to recover my land, there has never been a trial to deal with the dishonesty aspect of the claim. As such, I feel the commission inquiry is the appropriate forum for the true story of the circumstances of my dispossession to be finally heard. I am attaching various documents that I rely on to support my claim. And in addition, I have a number of other documents and evidence that I would like to submit at the appropriate time receiving guidance. I look forward to hearing from you as to the next steps. Yours faithfully, Robert Mulder. I have to take a drink. I'm just dying. And then in the final paragraph, it is not an exaggeration to say that the false court claim of adverse possession began in 2004, ruined my life. And in attempts to seek compensation, I have risked losing my home to pay court costs to the Slaughters, Miss Michael Cranfield, Stephen Cook, and Cox Allen Wilkinson, the very parties who participated in the false claim. The current situation is that lawyer Stephen Cook, Mr. Cook, has an application before the courts to try to sell my home at any value to pay costs. His lawyer is seeking to have my home sold at an undervalue using a form of writ known as vendictionio expones or something. I understand from the Attorney General's chambers, who have become involved and filed submissions at the attorneys of the Deputy Provost Marshal General, that this form of writ is not known to the rules of the Supreme Court of Bermuda, and the use of such writs can lead to arbitrary and repugnant results, leading to an undesirable consequences that can be shown not to be reasonably justifiable in a democratic society. The Attorney General's Chambers has also described this as a constitutional matter and seeks directions as to the sale of the property to ensure that it is in line with natural justice, that justice is seen to be done, and there are no breaches of the Constitution. This part of the matter is still pending before the courts, but I mentioned it here because to bring awareness of what's going on as I see the attempt to sell my house at any price as another attempt to wrongfully dispossess me and potentially set a dangerous precedent in Bermuda. That is the end of that letter.
Now, what is exhibit?
I'm sorry, I didn't hear you.
What is exhibit MC1? At page 1 of that document, the said letter which you read at the 8th of June 2020 letter. The last paragraph of the first page, the last 3 lines you have stated, I am confident that what happened is an example of the type systemic land grab that the Commission has responsibility for inquiring into, and believe that criminal wrongs were committed by various individuals that ought to be reported to the Director of Public Prosecutions.
Yes, sir.
You have started and you have mentioned some names. You also gave a statement dated the 19th of January 2021 in that statement, you set out what you allege is the role of law firms, bankers, and you wish the contents of the statement to be considered by the commissioners with a view to referring it to the DPP's officer?
Yes, sir.
Now, the statement of 19th January 2021, which consists of 3 pages, you signed that document, sir?
This particular one I have in front of me is not signed. But if you have one that you want me to sign, I'd be quite happy to sign.
I'm going to show you a document. I'm going to ask you if you see your signature there and if you recognize it, sir.
Yes, sir. Yes, sir. Absolutely.
What is that, sir?
Yes, sir. That is my signature, sir.
No, what is that document that has been shown to you?
The witness statement, sir.
Dated the 19th of January 2021.
Yes, sir. Absolutely.
And you have signed each page.
Yes, sir. I have.
And just to repeat, that's the document that you wish the commission to consider with regards to the role played by some bankers and some lawyers, and you wish them to refer that matter to the DPP's office.
Yes, sir.
I'd ask Chairman that the document, which is dated the 19th of January 2021, it's a statement of the witness, Mr. Robert Mulder. The application is that it is tendered and admitted as Exhibit RM2.
Yes, statement of Robert Mulder, consisting of 3 pages, dated 19th January 2021, tendered in evidence and indexed as Exhibit RM2. So indexed.
Before the, excuse me, before the witness, I'm sorry. Before the witness is invited to read what is Exhibit RM2, out of an abundance of caution, I preface the question in terms of a recommendation he wishes to place before the commission a document which he wishes the commission to consider, and ultimately, if so, the thinking of the commission to make a referral to the DPP's office with regards to the persons and the entities who are mentioned herein. The alternately, well, not alternately, but I know you had prefaced the start of the proceedings to indicate that adverse notices may be issued to persons, but I preface it to indicate that that could be done at this stage as we go through to alert persons that something is being said and a recommendation is being made that their conduct ought to be considered for criminal wrongdoing.
Yeah, Counsel, are you asking the commission to rise and consider the evidence as tendered being the basis for a complaint to the Department of DPP, the Department of Public Prosecutions?
Well, that is what the witness is asking to be done, but that is ultimately something that would be done when a report is being written by the commissioners and a finding will be made, having considered the information. The information is not yet before you. You have not heard it, though it's an exhibit. So at that time, when you are considering the documents, Chairman, you could so indicate by way of your report.
Yeah, Counsel, in addition, the witness has already named certain persons in this open commission. Should we consider that his utterances are enough for us to send adverse notices to those persons at this point?
That could be done properly, Chairman. Yes, that could be done
At this point?
at this point. But what I was trying to indicate, Chairman, is that the statement that the witness is about to read, he's going into detail to indicate what he believes is the, sorry, just a minute. What he indicates is a role played by each person. So that's why I was the role. So this statement that he wishes now to indicate a particular role of each person that he wishes to be considered and to be sent elsewhere.
Well, Counsel, at this point, since the allegation has been made that certain persons, as named, have committed offenses that would cause adverse notice to be tendered at a civil level, certainly, and he's now continued that complaint to include that they may be, and be allegedly, guilty of criminal matters, that takes this commission and our deliberations to another level.
It does.
And at this point, I would consider it prudent that we, the commissioners, discuss these matters in camera.
Very well.
And then, since they could form the basis of a criminal matter, should we send it to the DPP's office, we don't want to prejudice one way or another the outcome of any criminal inquiry. So I would consider it prudent if we adjourned to consider the exhibit as tendered, even though he hasn't given it in open forum. He has given it to us as a document, that we should consider that document. And I take your counsel.
That's proper, Chairman.
So at this time, you can guide me, but I'll say to the witness that this commission has taken into consideration your utterances indicating adverse notices being needed or required against named persons in the first instance, and in the criminal matter, the second instance, that we will adjourn so that we can make a decision.
Right.
And counsel, if you would join us
Certainly.
to help us to make that decision.
Yes, and I'll just add importantly,
Yes.
the mere fact that an adverse notice is issued to anyone, no person is duty bound to attend. But especially if you're now going to allege or suggest that criminal sanction should be brought, that person is subject to invoke self-incrimination and not to appear here, especially if that is being done. So I put that into on the table, Chairman.
Yes, counsel, we may, if we rise and come back with the decision, we may direct the witness in a certain way.
Very well.
Nevertheless, I think we should adjourn at this point.
Very well.
So,
Thank you.
adjourn. As long as it takes us.